Professor. Hearing for the defense alongside Magdalene Senior, the Honorable Eugene Wamalwa, Kevin Ondago, John Maina,
Present, Your Honor.
Pietra Wabinya,
Present, Your Honor.
Onchuari Yamali.
Present, Your Honor.
You know, we have the 6 names there. With me, I have Mr. Nyaga.
Present, Your Honor.
I'm present for the state. He's coming up for me.
The name of the other counsel.
Yes, can you present for the state? We also have our senior colleague here.
Yes, Your Honor. Good morning. My name is Sonny. So hearing.
As he gave directions, the matter of the phone, when Mheshimiwa connected with his app, it was resolved. So here it is. Part of the
the accused was presented before the court on the 19th of May 2025, where the plea was taken and was released on board. Several issues were raised, and the court reserved the following two main issues. One was whether the accused's rights were violated, that was arrested, and writs of order thereby the defendants. The other issue was whether the court was permission to order his arms aside to security. I took into account the submissions by defense team led by Mr. Tegesa, submitted that under Section 8 of the Magistrates Act, this court has powers to inquire and give interest to violation of rights. That's under Article 25 of the Constitution. Court should address the manner in which the accused was arrested. That he was arrested in a valid manner, and cited the following instances. One, that an identified person shot at the rear tire of the accused car was intercepted without self-identification, bundled into another car, driven to a disclosed destination, was held in community transport, and disadvantaged staff, relatives, denied access. The manner of arrests and subsequent treatment amounted to inhuman and degrading. Victim did not befitting a sitting member of parliament. Further, that the accused has never been summoned by National Coalition and Integration Commission, PCI, or the police on hate speech, and it's quite regretful for his bodyguards to be disarmed. Communication gadgets confiscated. It was finally submitted that his bodyguards are reinstated as withdrawal violates Chapter 32.8 of the National Police Standing Orders on VIP protection. State submission prosecution that police officers are allowed to use force to arrest, and from the demeanor, the accused appears fit. That this was not a proper forum to address the issues raised as the issue of constitutional rights. We have the constitutional court and also IPOA. It was also submitted that an application to reinstate the arms is a misdirection and should be raised in the proper forum. Finally, nobody's above the law. I have considered the issues which has been raised by the councils for both sides, accused and the response by prosecution. I will turn the preliminary issues which was raised as issues for determination. First is whether the accused rights were violated in the course of arrest, and if so, what are the available remedies, and whether the court has got jurisdiction to order release of the arms assigned to the accused security. On the first issue, the defense referred to Section 8 of the Magistrate Act and submitted that this court has got powers to inquire into the violations. I've looked at the said Section 8 of the Magistrates Act, which I reproduce for the purpose of clarity. What? 8.1 are subject to Article 165 3b of the Constitution and pecuniary limitations set out in Section 7.1. The Magistrates Court shall have jurisdiction to hear and determine application of redress of a denial, violation, or infringement of threat to a right or a fundamental freedom in the Bill of Rights. 2. The application contemplated in subsection 1 shall only relate to rights guaranteed in Article 25 and B of the Constitution. 3. Nothing in this section, in this act, may be construed as conferring jurisdiction on a magistrate's court to hear and determine claims for compensation for loss or damage suffered in the consequence of violation, infringement, denial of a right of fundamental freedom in the Bill of Rights. 4. The Chief Justice shall make rules for the better exercise of jurisdiction of the Magistrates Court under this. Reading this section, it is clear that the Magistrates Court have jurisdiction here to application for denial, violation, or infringement of threats to right or fundamental freedom in the Bill of Rights. It is restricted only to the rights guaranteed in Article 25 and B of the Constitution. And Article 25 and B of the Constitution provide as follows, and I quote, fundamental rights and freedoms that may not be limited despite any other provision in the Constitution. The following rights shall not be limited. That is, freedom from torture, cruelty, inhuman or degrading treatment, freedom from slavery and servitude. This court therefore has got powers to deal with the issues revolving around freedom from torture and cruel, inhuman and degrading treatment, as well as freedom from torture and servitude, and give redress where applicable. There is no doubt that the accused was arrested and put in custody. Other than the submissions from the council about mistreatment, I did not find any concrete evidence to show that the accused was subjected to torture, inhuman and degrading treatment. He was before this court for plea, and I did see any evidence to demonstrate that he was tortured when he arrested. And from his appearance alone, he appeared fit and did not show any signs of having been tortured or mistreated, or even subjected to slavery. Under the circumstances, I find no evidence to show that his rights as contemplated under Section 25 and B were violated, and the application by defense stand dismissed. The other aspect is an application to direct release of the firearms assigned to security details. In this front, the prosecution submitted that the state was in a possession of one Salasya pistol loaded with 15 rounds of ammunition, and it's part of inventory. It is documented, and apparently it's part of experts. This court cannot, at this stage, tell the evidentiary value of the arms taken, including the ammunition, considering the charges facing the accused. We shall wait for evidence to be tendered. It will be subjected to cross-examination by defense. And it's my finding that this court lacked jurisdiction to direct release of exhibits until it is formally produced. The accused, however, have a right to protection by state and should be accorded security within the established protocols. Lastly, it's the issue of what, which is the case that you talked about, just taken from the accused and summon the investigating officer to appear before this court to offer explanation. And from the look of things, that thing apparently has been settled. I don't know anything about it. Can we then have a date for retrial? State, how many days do you need? Have you supplied the documents necessary?
How much is your we shall supply in due course. Then I can get a mention in 2 weeks to confirm the necessary.
Then come back on the confirm Mr. Defense whether you are available either on the 16th or 17th or the 18th or 18th.
Your Honor, we are available, but we shall be seeking the indulgence of this court to allow the accused to be virtually in the away for a committee meeting. This court will now have this best of can ever dispense with his attendance. If it is mandatory, he can do so virtually.
I guess prosecution, your operations with that factor is part of the an issue.
No, no objection.
But we shall do the trials by way of mention accused to attend both factors.
Much obliged, Your Honor. And have a good day for the two.
What are the assigned conditions? Calvis.